The case for punishing James Fiegel, United States Marine Corps veteran, for the crime of harassment in the second degree has become the case for indicting Judge Caren Loguercio, who is both an acting New York State Supreme Court judge and the supervising family court judge in Central Islip, for making a punishable false written statement and removing Judge Loguercio from the bench and the practice of law. In short order, I will provide evidence that Judge Caren Loguercio has committed the Class A misdemeanor of making a punishable false written statement in order to stop a court watcher, United States Marine Corps veteran James Fiegel, a member of the public, from monitoring the courts using a falsified criminal complaint of the violation of harassment to facilitate a stay-away order of protection. It is critically important to recognize that as a judge, Caren Loguercio is the final arbiter of the record in the cases that come before her court, possessing the emolument of judicial immunity from all prosecution unless there is a complete absence of all jurisdiction, all in support of her judicial impartiality. You will be asked to decide if she is still worthy of being the supervising judge of the Suffolk County, New York Family Court in Central Islip, or if judicial accountability is in order. The model for the scene of the alleged crime was preserved for the criminal defense of James Fiegel, United States Marine Corps veteran, regarding the criminal harassment charge of New York State Penal Code Section 240.26 sub 2 alleged by Judge Caren Loguercio.
Good morning, Judge. Would you like to comment on the death of Tommy Valver and how CPS failed him miserably? The district attorney said if CPS did their job, Thomas Valver would be alive today. Well, I say if family court did their job, Thomas Valver would be alive today. Good morning, Supervising Judge Loguercio. I'm having a problem with Judge Hughes closing the court to the public while allowing his lawyer friends, even though he cites Catherine B. I emailed you about it and I haven't heard anything back. Can I expect a response? The public and myself are waiting. Thank you. Good morning, public and good people. Let's see if the supervising judge is in agreement with Judge Hughes closing the courtroom to the public while simultaneously allowing his lawyer colleagues and friends to stay in the courtroom. Judge Loguercio, do you agree with Judge Hughes' practice of closing the courtroom to the public and allowing his lawyer friends and colleagues to stay in the courtroom? Good folks, this isn't her practice. She does the right thing. And when there's sensitive information, all attorneys, it makes sense. Through Waller, through Hinton. When is enough enough, good people? Surely we could do better than this. Good morning, Judge. Would you like to comment on the death of Tommy Valver? Now, CPS failed him miserably. Shame on them.
On the afternoon of October 24th, 2024, Mr. Fiegel was court watching in Judge Loguercio's courtroom, and the judge made the decision to close the courtroom to the public without allowing any public comment. She did this by leaving the bench and walking out of the room, thus terminating the record. Mr. Fiegel stood up and said, "Let the record show the judge has left the courtroom." For that, he was detained. On the morning of November 6th, 2024, there were several recordings made. Mr. Fiegel made 2 recordings, the first of which was not made public until April 22nd, 2025. There were several recordings at the courthouse that were made, but not preserved by the assistant district attorney. The 3 cameras in the back of the courthouse only preserved a segment of the occurrence, while the cameras towards the side of the building, which would have had exculpatory evidence for Mr. Fiegel, were completely unpreserved.
She walks off the bench, not allowing the public to speak. It's despicable, good folks. A shame. A shame. Why is that? Following Judge Hughes? To me, it's a disgrace, good people. Shame. Good morning. How are you?
Good, how are you?
Good, thank you. Have a good day. Good morning, Judge Loguercio. Can I ask a question on why you leave the courtroom and close the courtroom to the public without giving them an opportunity to speak? No response? Good folks, is this what we get from our judiciary? Is this fair? I got detained coming out of her courtroom, good folks. As a man, a veteran, and member of this community, certainly we could do better than this, good people. We have to hold judges accountable. They are not above the law. Good folks, they use sneaky practices of running off the bench. How could that? And we have to hold them accountable. Absolutely. When is enough enough, good folks?
As they say, the devil is in the details. And here we have the details. Fortunately, Mr. Fiegel's phone preserved evidence of not just the minutes, but the seconds, which is critically important in this analysis. The start of the first video occurred at 8:18 in the morning and 43 seconds. The start of the second video started at 8:21 in the morning and 20 seconds. There is a gap between the two of 2 minutes and 12 seconds. So let's take this step by step. The distance that Judge Loguercio and Officer Boyle traveled during the first video was approximately 56.5 feet, and that was done in 25 seconds. So they were traveling at roughly 2.25 feet per second. On the other hand, you did see some movement from Mr. Fiegel, and he moved approximately 27 feet in the 25 seconds. So he was meandering along at about 1 foot per second. Okay, there is another 91 feet that Judge Loguercio and Officer Boyle travel to reach the back door. And it would be expected at their current rate of walking for that to take approximately 40 seconds. And upon reaching that door, it would take about 10 seconds to enter, according to one of the other videos. And of course, Officer Boyle would take another 40 seconds to walk back. So the anticipation, based on all of this information, is that at 8:19 and 58 seconds, Judge Loguercio should have been in the building. She was not. Mr. Fiegel had no way of knowing this. Now, Mr. Fiegel had to walk 104 feet to begin that second video. And at his rate of walking, and to cover it from the time frame from when it, reversing back from when it started, 8:21:20, he would end up walking at 2.5 feet per second on average, starting at 8:20 and 38 seconds, well after he would have expected Judge Loguercio to be in the building. Now, it wasn't until 38 seconds into that second video that he actually discovered that Judge Loguercio was still outside. Now, the length of time that Judge Loguercio was outside of Mr. Fiegel's presence was 2 minutes and 50 seconds. The length of the second video was 2 minutes 17 seconds, and the second video ended at 8:23:37. Now, if Mr. Fiegel had immediately followed Judge Loguercio the 225.5 feet from his initial position to that back door, it would have taken just over 90 seconds, and he would have arrived there at 8:20 and 13 seconds. Fully 1 minute and 45 seconds before he did. So now we're going to investigate, did the judge lie? The people of the state of New York versus James Fiegel. I, Caren Loguercio, date of birth 9/14/68. At approximately 8:20 this morning, I parked my personal vehicle in the family court employee lot located at 400 Carlton Avenue, Central Islip, New York, 11722, Town of Islip, County of Suffolk, State of New York, and immediately saw a person known to me as James Fiegel, who was wearing an orange vest and holding signs. In an attempt to avoid him, I went towards a rear door of the family court building, not the regular employee entrance door that I usually use. Court Officer Thomas Byrne came over to walk with me, and Mr. Fiegel immediately started to follow me. Court Officer Byrne and I were unable to open the door and had to wait to gain entry. Mr. Fiegel stayed in the rear area and continually loudly addressed me in an attempt to get a response as he was recording the incident. He was referencing a previous incident in my courtroom and was accusing me of being sneaky due to the fact that I left the bench after a ruling. After waiting a minute with no entry, we decided to walk away from Mr. Fiegel and back towards the main employee entrance because I was very uncomfortable with Mr. Fiegel's behavior. Mr. Fiegel continued to follow me as I was walking back and continued to loudly address me the entire time. His behavior made me feel harassed, annoyed, and alarmed. He has done this to me numerous times, and I want him arrested. In order to prove that Judge Caren Loguercio committed a criminal act pursuant to Section 210.45 of the New York State Penal Law, making a punishable false written statement, there are two elements that need to be proven. The first is that the instrument, the criminal complaint in this case, bears a legally authorized notice to the effect that false statements made therein are punishable. And that is certainly the case. It was on the full statement. The second element is a person is guilty of making a punishable false written statement when he or she knowingly makes a false statement which he does not believe to be true in a written instrument bearing that legally authorized form notice to the effect that false statements made therein are punishable, which is a Class A misdemeanor. So we're going to go back through the statement. We're going to look at it item by item, and we're going to inquire as to whether or not Judge Loguercio knew or reasonably should have known that what she was doing was making a false statement. So we have shown clear and convincing evidence that for 1 minute and 45 seconds that Judge Loguercio knew that Mr. Fiegel was not present with her in the back, which he would have been had he immediately followed her. Therefore, she did knowingly lie on the criminal complaint. And as such, there's clear and convincing evidence that she has committed a Class A misdemeanor pursuant to New York State Penal Code Section 210.45. There's a legal maxim that says false in one thing, false in all. So going through her criminal complaint, we see evidence of other false statements. For instance, Mr. Fiegel stayed in the rear and continually loudly addressed me in an attempt to get a response as he was recording the incident. I'm going to skip down. After waiting a minute with no entry, she was not there in the back with Mr. Fiegel for more than a few seconds. That was not a minute. And as a trained observer, a judge, she should know. She should also know, since he was loud enough, that he was not addressing her but for two questions. And instead, he was loudly addressing his audience in her presence. That she made the statement that she felt harassed, annoyed, and alarmed is direct verbiage from the harassment statute. And as a judge, she would certainly know that language is something that will cause him to get a restraining order to stay away from the courts, which is the very likely motive that she committed a Class A misdemeanor in order to saddle Mr. Fiegel with a criminal violation that had a maximum penalty of $250 and 15 days in jail. The court officer Thomas Byrne and the ADA Carson Gogans both bowed to the pressure of facing a politically appointed judge with unbridled power and a complete absence of accountability to the people. While District Attorney Ray Tierney and his office withdrew prosecution during motion practice to dismiss the case against Mr. Fiegel, Caren Loguercio's actions have cost Mr. Fiegel mounting legal expenses and denied him his rights, including his right to court watch the Suffolk County Family Court in Central Islip and his right to be heard in respect to closing the courts before it's deprived, and his right to bear arms. Although he should, District Attorney Ray Tierney cannot reasonably be expected to expend resources to bring charges that will only be met with dismissal based on judicial immunity. After considering other options for judicial accountability, I will address the issue of judicial immunity more fully here. The administrative judges, under the theory of judicial independence, to preserve impartiality, should publicly issue administrative orders that the courts shall remain open to the public unless the proper constitutional procedure is followed to close them, such as the Court of Appeals did in the case of the People v. Reed, May 23, 2023. And that under the Sixth Amendment, the right to compulsory evidence, that all court proceedings may be electronically recorded by or on behalf of the parties before the court for the limited purpose of correcting or validating transcripts, official court transcripts. Finally, Judge Loguercio should be removed from the bench. There is no reasonable expectation of any of that happening. There is only the expectation that the silent mockery of justice by those who hold themselves above the law will continue. The Commission on Judicial Conduct should review this matter and remove Judge Loguercio from the bench, but the members work in secrecy from the public and have a supermajority of members of the Bar Association, as opposed to having oversight by the people of the state of New York. Matters brought before them by those who are not members of the bar are routinely discarded. The petition for the New York Assembly Judiciary Committee to investigate Judge Loguercio for impeachment suffers from the same challenges as the Commission on Judicial Conduct, and no judge save the one in 1873 has ever been impeached in the state of New York, and after 1977 all such actions are referred to the Commission on Judicial Conduct. The final recourse of the voters to take action is also thwarted in that there is no mechanism for recalling a judge. There isn't even any mechanism for voting judges into office, as they are pre-selected by party leadership through negotiations to run for office unopposed. As supervising family court Judge Caren Loguercio can reasonably be expected to be the best that the judicial branch of government has to offer the people, there is no legitimacy to this branch of government because there is no meaningful oversight by the people or their representatives. At every point, the Bar Association has thwarted this. If we, the people, and those who employ trustees of our Constitution, choose to allow judges to act criminally without accountability, then we will surely get the tyranny that we demand with our silence. The children that she facilitates harm to today through deprivations of due process are the ones who will more likely be to interact with the criminal courts in the future. Is Caren Loguercio still worthy of being considered as a judge? I think not. Was she a judge in her official capacity and the emolument of immunity applicable when she made her criminal complaint, or was she a woman in her personal capacity? Well, in the federal courts, the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, Constitution Article 3, but the state of New York is different. Case law suggests that criminal activity cannot fall within the official duties of a judge. A judge acquires their official character, to which their emolument of judicial immunity exclusively attaches to upon the signing of their oath of office. A judge who commits a criminal act strips themselves of their official character to perform the criminal act in their personal character. There is no statutory mechanism to reacquire their official character once stripped, short of reappointment and retaking their oath of office. When Caren Loguercio knowingly made the false statement on her criminal complaint against Mr. Fiegel, she committed a crime in her personal character which is not protected by the emolument of judicial immunity. In summary, Caren Loguercio acted in a malicious and criminally vindictive manner to stop a court watcher from exposing the patterns of wrongdoing within our courts by attempting to convert James Fiegel's First Amendment rights into a crime, all while portraying herself as a victim. She used the classic silver bullet technique to falsely allege that a male whom she decided that she didn't like was dangerous and that she needed to be protected from him. Under the preponderance of evidence standards, and as an abundance of caution of his rights were denied. This technique is very commonly used in family courts where only the preponderance of evidence applies for one party to gain an advantage over the other party. Mr. Fiegel was only saved from this bullet by having gained access to recorded evidence that not only exonerated him, but proved that she lied under the higher clear and convincing standard of evidence. Caren Loguercio tried and failed to have Mr. Fiegel prosecuted the previous week, or arrested and prosecuted the previous week, so she tried again, and had no concerns about using false claims against him because they are never prosecuted, and she had judicial immunity anyway. A judge must be held to a higher standard, and this cannot be allowed to go unaddressed, as she rendered herself unfit to sit on the bench through the combination of her poor judicial skills, her moral turpitude, and her criminal conduct. Ultimately, this is a battle of intent. Mr. Fiegel's intent to hold the judiciary accountable to the people, and Caren Loguercio's tyrannical intent to prevent that from happening. The people, through our elected officials, must hold Caren Loguercio accountable if the legitimacy of government is to have any real meaning. Wherefore, I, James Kelly, as one of we the people, do hereby move the Suffolk County, New York District Attorney Ray Tierney to indict Judge Caren Loguercio for the crime of violating New York State Penal Code Section 210.45, making a punishable false written statement and prosecuting her, and further move the Chief Administrative Judge of the State of New York to issue administrative orders that the courts shall remain open to the public unless proper constitutional procedure is followed to close them, that the people shall have the right to be heard on that closing, and that under the Sixth Amendment right to compulsory evidence, that all court proceedings may be electronically recorded by or on behalf of the parties before the court for the limited purpose of correcting or validating transcripts, and further, move the Commission on Judicial Conduct to permanently remove Caren Loguercio from the bench and the practice of law, and further, move the Inspector General of the New York State Unified Court System to investigate the overuse and unconstitutional closure of the courts without the correct procedural due process, and further, move the public to support or oppose these actions by their comments, both on social media and directly to the individuals and organizations so moved. And further, move James Fiegel to petition the New York Assembly to investigate Judge Caren Loguercio for impeachment proceedings if necessary, and or to file an Article 78 proceeding against Judge Caren Loguercio in the nature of prohibition containing a criminal misdemeanor information for her moral turpitude in the New York Court of Appeals pursuant to the Constitution for the State of New York, Article 6, Section 22, Sub F. Caren Loguercio has undermined the public trust and confidence in the judiciary while devaluing actual victims of real harassment. This is not acceptable and cannot be accepted. While I cannot speculate as to whether she would feel harassed or annoyed by this, I do believe that a sitting judge who would commit a Class A misdemeanor in order to attempt to convert a protected First Amendment right into a crime to facilitate her personal narrative and to chill the public's access to the courts is shocking to the public conscience to the degree that every one of we the people ought to feel alarmed.